This is the What Just Happened series of the Just Security podcast. I'm David Aaron, and it's August 19, 2025. The goal of the What Just Happened series is to explain the background and implications of legal and policy developments that may not be immediately apparent. We bring our own national security and government experience to the table, and we bring in guests to share theirs. With that collective experience, we can shed light on the significance of events in the news. Last week, after the Trump administration announced that it was taking command of the Washington, D.C. Police Department, sending federal law enforcement agents to conduct street-level operations, and deploying National Guard units to the city, we talked about policy questions and potential red lines for those actions. Today, August 19, a little more time has passed, and there have been some legal developments. So we're going to dive deep with our two guests into the legal bases for the administration's actions toward the Metropolitan Police Department and its use of National Guard units from DC and other states. Our guests are expert in these areas. Brian Netter is legal director at Democracy Forward. He was previously Deputy Assistant Attorney General in the Civil Division at the U.S. Department of Justice. And before that, particularly relevant today, he represented the DC Council in its defense of the Local Budget Autonomy Amendment Act of 2012 under the DC Home Rule Act. Mark Nevitt is an associate professor of law at Emory School of Law. He previously was the class of 1971 Distinguished Military Professor of Leadership and Law at the United States Naval Academy in Annapolis, Maryland, associate professor at Syracuse University College of Law, and the Sharswood Fellow at the University of Pennsylvania Law School. Mark's recent article for Just Security examining the use of National Guard units in DC is linked in the show notes. Brian, Mark, thank you for being here. Start out by just baselining the legal authorities and gray areas for the different moves the administration has made. Brian, a lot of the activity regarding the Metropolitan Police Department centers around Section 740. Can you talk to what Section 740 is and break it down into its elements so we can understand what conditions have to be present?
Sure. Thanks, David. So Section 740 is part of the DC Home Rule Act of 1973. And that's the statute that identifies which functions are going to be performed by local officials for the district and which functions are going to be retained by the federal government. Section 740 says that even though the Metropolitan Police Department is going to generally remain under the control of the elected local officials, the mayor, if there's an emergency situation, the president is allowed to requisition the services of the Metropolitan Police Force for federal purposes, where there are special conditions of an emergency nature. So what are these conditions then? What does special conditions of an emergency nature mean is not really an issue that has been defined. But what we know from the legislative history is that this came from a bill from the House of Representatives that required only special conditions. And the conference committee added the emergency nature qualifier. In addition, the services have to be for federal purposes. Now, the whole point of the Home Rule Act was to identify local purposes and to create a local government that would be responsible for performing those local functions. We don't need to wonder how Congress viewed policing. There were proposals for the DC police to remain a federal force or for the chief of police to be a presidential appointee confirmed by the Senate. But Congress ultimately rejected that path and left policing, local policing, as a local function under the control of DC's local government.
Excellent. And in addition to the predication, what triggers or allows the president to invoke 740, what does 740 allow him to do with regard to the police department? Because there seems to be a difference between a full-on takeover and having to go through the existing governmental structures in DC.
So this was a subject of the litigation we're going to discuss, but just to start with the statute here, it says the president may direct the mayor to provide him, and the mayor shall provide such services of the Metropolitan Police Force as the president may deem necessary and appropriate.
Thank you. And then there's a time limit if the president does invoke this of 30 days?
Yeah, the maximum time frame for the presidential control, whatever the extent of that control is 30 days, unless he goes back to Congress, and Congress enacts a joint resolution, which is effectively a new law.
All right. Thank you. Mark, let's shift to the baseline legal authorities governing the National Guard. First off, and the answer might be different for DC and state guard units, but what is the chain of command going up from the National Guard?
Sure. So maybe I'll start with DC because I can say with much better certainty the chain of command of the DC National Guard. The DC National Guard has a one-star brigadier general. He's an interim right now. I don't believe he's Senate confirmed. Brigadier General Blanchard, who is the commanding general of the DC National Guard. And its authorities are a bit unique amongst National Guards. We'll get into that maybe a little bit later. But the president clearly has authority over the DC National Guard. It can use the DC National Guard in the chain of command without first invoking what's known as the Insurrection Act. There's an executive order that's signed from I think the Johnson administration or maybe the Nixon administration, where the supervision and direct control of the DC National Guard flows from the Secretary of Defense to the Secretary of the Army, which is currently a person by the name of Dan Driscoll, who was a classmate, I believe, of the vice president at Yale. So the chain of command of DC National Guard, in my estimation, is relatively simple. The mayor is not in that direct chain of command today as we speak, but it goes from Brigadier General Blanchard up to Secretary of the Army Dan Driscoll, to Secretary Hegseth, to the President of the United States. Now, the 6 state National Guards is quite different. As your listeners may know, West Virginia, South Carolina, Ohio, Mississippi, Louisiana, and as of this morning, Tennessee have all answered the call, so to speak, to send National Guard units to Washington, D.C. It's my estimation and my understanding that those are still under the chain of command of the respective state governors. But it's unclear exactly how they're being coordinated with the DC National Guard. I will note that in 2021, then Secretary of Defense Lloyd Austin, recognizing that this is a little bit messy when out-of-state National Guards came to DC in 2020, he tasked the Secretary of the Army to play a key role in coordinating the employment of the DC National Guard with other state National Guard forces. So Secretary of the Army Dan Driscoll is a very busy man today as he's thinking about how to coordinate these really 7 units into DC, and how that is actually going to work out is going to be very, very interesting to follow. But the upshot is those 6 state National Guards are under the control of the state governor. And I would think that would be something that the state governor would want to keep in case they need them back home for whatever reason.
Sure. So, I mean, in the ordinary course, a National Guard in a state outside of DC answers to the governor unless they're federalized, unless they're brought under the command of the Department of Defense, correct?
That is correct. So there's different status for the National Guards, and we can talk about sort of these emergency management agreements. This is a bit unique because we know that Muriel Bowser hasn't requested these guards to come to her state. The requests flow through the federal government via President Trump. And so, but the chain of command, I think, is a bit messy right now.
And so, at least in the case of the DC Guard, what statutory authorities or other legal authorities govern when they can and can't be, called out into, the streets of DC for service?
Sure. So another good question. So the DC Code will speak to this. There's another sort of provision of the DC Code which is pretty broad in terms of when they can actually be used in the nation's capital. And there's another provision called other duty within DC Code, which is not well defined, unfortunately, but has been construed to give the president pretty broad authorities. Maybe we'll get into this a little bit later, but sort of a key question is, do Posse Comitatus Act restrictions apply today to the DC National Guard? And as a general matter, David, state National Guards, when they operate under state status or what's called Title 32 status, those Posse Comitatus Act restrictions, which essentially restrict the military from being used in the law enforcement capacity, would not apply. the DC National Guard is just different from all other National Guards. And so we have very little guidance on does the Posse Comitatus Act restrictions apply today? The best I can say is that the DOJ does have pretty strong arguments that the DC National Guard is not prohibited from or not prevented from doing law enforcement based upon a couple prior OLC opinions from the 1970s and 1980s when the DC National Guard was tasked to protect federal functions and then actually was tasked to help in the drug law enforcement mission. But what we're asking here is essentially maybe immigration enforcement, maybe sort of a different role, a more aggressive role of the DC National Guard, potentially. But as we see in the ground right now in DC, it's more a posturing, it's more a presence. But this question of posse comitatus, I think, is going to rise to the fore if they're asked to do more.
I can definitely commit we will talk more about posse comitatus in this episode. So we'll circle back to that. Thank you for that background. So Brian, as you indicated, just pivoting back to the police, there is newly commenced ongoing litigation regarding the federal engagement with the Metropolitan Police Department. The president issued an executive order on August 11, invoking Section 740, declaring special conditions of emergency that require the use of the MPD for federal purposes. And that included protecting federal buildings and property and ensuring conditions necessary for the functioning of the federal government. That was followed on August 14 by the Attorney General's issuance of an order, number 6370 of 2025, and that did a few things. It declared that the DEA administrator would serve as something called the Emergency Police Commissioner of the MPD, which I had never heard of that position before. It rescinded 3 orders issued by the MPD Chief of Police, limiting MPD involvement in immigration enforcement. And then the last bit directed MPD to enforce a DC code provision about unlawful occupancy of public spaces to the maximum extent permissible by law. And before we talk about the litigation, just pause there for a second. I mean, the first part appears to be maybe an overreach, but it tracks the administration's stated intent. Those next 3 have a clear purpose that's consistent with the administration's rhetoric on immigration. The last part targets occupancy of public spaces. And although it has the word unlawful in there, it just reminds me, I started out my career as a local prosecutor in Manhattan, and we saw multiple times that the law enforcement approaches to protest activity can vary in style and carry very different messages. So referring to that first order from the Attorney General, Brian, what do we make of that, particularly the last bit?
Well, so I think we have definitely seen stepped up police involvement in First Amendment expressive activity that presents real constitutional concerns. But my sense is that the primary objective of that provision was to prompt the evacuation of homeless encampments on public lands. So prior to the attempted police takeover, the U.S. Park Police had, during this administration, already removed 75 such encampments from federal parklands, but they wouldn't have had the authority to remove an encampment on land owned by the local government. Oh. The district has been operating under a protocol to engage with individuals camping on DC-owned land and to provide access to more stable housing where possible, to provide access to mental health facilities. Some of these encampments are surely a result of political protests themselves. But the DC method had been a form of triage, of removing encampments when there's a safety issue, but otherwise trying to help the people who are involved. And the federal approach has just been to clear out tents as quickly as possible.
So then I guess that raises the question indirectly of whether under Section 740, the president's directions to MPD have to be related to a describable emergency. Does every directive that the president gives or the attorney general gives have to relate back to the emergency that triggers the invocation of Section 740? I don't imagine there's a clear answer to that.
It's not an issue that's been litigated, but it's hard to come up with a purpose for the statute whereunder the president could declare an emergency and then use the Metropolitan Police for totally unrelated purposes. So by implication, I think that has to be a requirement.
Well, we may find out, because on August 15th, the Attorney General of DC, Brian Schwab, filed a complaint seeking injunctive relief against the order that Attorney General Bondi issued. Brian, can you just go over in broad strokes the complaint and what happened so far in that litigation?
Sure. So the DC Attorney General's office filed this lawsuit remarkably quickly after the Bondi order. The order came out overnight on the 14th. By the morning of the 15th, there was a lawsuit. And by the afternoon of the 15th, the parties were in court before Judge Anna Reyes in DC on a motion for a temporary restraining order. Judge Reyes said at the outset of that hearing that there were factual questions that just wouldn't be suitable for same-day resolution, such as whether the federal government had a federal function for its operations. But she quickly engaged the parties on some pure questions of law. Now, a moment ago, David, you alluded to the first part of this Bondi order as being particularly problematic, perhaps. That's the provision that specified that DEA Administrator Terry Cole would serve as MPD's emergency police commissioner, and that also allowed him to assume all of the powers and duties vested in the DC chief of police. The DEA social media accounts were quick to post a new DC Metropolitan Police badge assigned to Cole shortly after that happened. And the effect of that action was to take the DC police out of the control of Mayor Bowser and her police chief, Pamela Smith, and to put the police directly into a federal chain of command. But Section 740 doesn't say that the president gets to take over the DC police. It says that the president may direct the mayor to provide him such services of the Metropolitan Police as he may deem necessary and appropriate. So Judge Reyes questioned the parties about whether this was a significant distinction, the requisitioning of services as opposed to the exertion of command authority. But it was pretty clear from the outset that she found the federal government's assertion to be beyond the scope of their authority. And the other parts of the original Bondi order purported to rewrite the Metropolitan Police Department's rules about cooperation with federal immigration authorities, and also to direct the stepped-up enforcement that we just discussed about homeless encampments. With respect to immigration, the message from Judge Reyes was, I don't see how you get to change the policies that they use for local law enforcement purposes, but you should think about whether you can achieve your objectives using the powers you already actually do have.
And so the outcome of that hearing seemed to be the parties met, they conferred, and the Attorney General withdrew her order and issued a new one. It changed the role of the DEA administrator first. Now the administrator is a DOJ designee for the purpose of directing the mayor, as you say, to provide MPD services instead of giving him direct operational control. It listed out on the immigration side several specific MPD services that were supposedly or declaredly necessary to addressing the emergency, such as enforcing immigration law, running database checks, providing information. And then it has that provision again about the DC code section about public spaces. Doesn't include the same blanket directive to enforce to the maximum extent permissible, but it rather says enforce that section as deemed necessary and appropriate by the administrator. Brian, I don't know if it's too soon to tell, but how significant do you see these differences, and what are we hearing about the impact of the revision to the order?
I think as a starting point, this is undoubtedly a major win for the District of Columbia. And the police are now back under local control. Perhaps they always remained under local control. And that was the whole point of having home rule in the first place. Now, as to the question of what this means going forward for cooperation between the Metropolitan Police and federal law enforcement officials, it may be too soon to really understand that. There have been some ongoing actions by the Metropolitan Police that maybe aren't ones you would have seen before the invocation of Section 740, but that's not entirely clear. In any event, much of the focus in the news media since Bondi changed course here has been on the actions of federal law enforcement agencies and the deployments of the National Guard.
Possibly to compensate for any reduction in control that DOJ or the executive branch has over MPD.
Seemingly so.
Yeah. Well, in that regard, Mark, as promised, it's time to talk a little bit about the Posse Comitatus Act, and probably also the Insurrection Act. We talked about the basic authorities for the use of the Guard. Can you talk to the role of both the Posse Comitatus Act and the Insurrection Act when it comes to the out-of-state National Guard units that are deploying in DC?
Yeah, I'm happy to do so, David. It might be helpful we just go back a little bit to the predicates for the out-of-state National Guard in DC and just unpack that a little bit more, if that's okay
Absolutely, absolutely.
with you, because the DC National Guard and the other National Guards are just different. And so what we think is that the president is using this authority called 32502F authority, where he's requested National Guard members in support of operations of missions undertaken at the request of the president himself. We haven't actually seen anything from Attorney General Bondi on what exact legal authority is being employed by the Department of Justice and the president in bringing in these 6 National Guards into DC. But I estimate that they're just running the same playbook from 2020 when they use kind of this obscure authority, 502F, to under this other duty sort of language to bring in, at that point, it was 11 National Guards in the aftermath of the George Floyd protests, and there was some illegal activity happening during that time. So, but the outer bounds of that is just unclear. In a normal situation, and this is not normal, the other National Guard units would come into DC under some kind of emergency management assistance compact where the mayor would welcome them in. And there'd be some sort of agreement or stipulation between the mayor and the other National Guard units or other law enforcement units about how they will operate in DC. So that the EMAC agreements have been very successful and essentially allowing states and the DC to sort of bring in outside help when you need them. But this is at the request, not at Mayor Bowser, between sort of the state or district sovereign. It's at the request of the federal government. So there's an open question about if this was to go to law enforcement, and it does get to your posse comitatus question, under what authority would they be operating under? Because normally under these emergency management assistance compacts, the outside members would be deputized, they'd be sworn in, there would be some kind of agreement about what exactly they can do, the left and right limits, and that is just not happening here. And so Mayor Bowser, as far as I can tell, is not pleased with these outside guard units coming in, but how exactly they'll be employed is just a very, very open question. And so I'm happy to get to the Posse Comitatus Act question next, which is sort of, I think, important because, as we know, the DC National Guard, as I mentioned, there is a strong argument that the Posse Comitatus Act restrictions, which would allow the DC National Guard to arrest, search, seize, detain, consistent with constitutional protections, consistent with DC code, doesn't necessarily apply. And we have some OLC opinions that would bolster at least the DOJ's argument that they don't apply. Though I will say that this is not a clear case, an open and shut case for the Department of Justice. They'd have to litigate this, and they would have to analogize to the drug actions and other sort of protective functions that were employed in earlier times. For the state National Guard, really, I'm very curious to know what exactly is their mission? What are they doing? What laws are they enforcing if DC doesn't want them there? And this became a mess in 2020, David, when you had these 11 National Guards there for a week, but then they withdrew because almost these questions that we're asking on this podcast were too difficult and they weren't good answers from the elected officials at the White House at the time. And so they basically, they withdrew and things kind of calmed down. But, generally speaking, the Posse Comitatus Act doesn't apply to state National Guards. The president can overcome that if he was to invoke what's known as the Insurrection Act. And frankly, that would make the chain of command a little bit easier because they'd be all under one federal umbrella, although that would be a remarkable step that I hope the president doesn't turn to.
So in the ordinary course, just to sum it up, at least outside of DC Guard, Posse Comitatus Act limits the degree to which National Guard can, or military can participate in law enforcement activities. They might be able to provide some support activities or some protective activities, but they don't have investigative or arrest authority, generally speaking. Is that correct?
Yeah, so I think of it in two buckets. The first bucket, you have the Title 10 federal military force bucket, and you're exactly correct. So the Army, Navy, Air Force, Marines, Space Force, when operating in a Title 10 federal status, they can't arrest, detain, search, seize, do law enforcement activities because of this 1878 law, the Posse Comitatus Act. That could be overcome if the president were to invoke the Insurrection Act, which the president has done in prior years, prior presidents, to federalize either the National Guard or the federal military forces to enforce federal law. That happened most recently in Los Angeles in 1992. But the state National Guard, when they are under the command and control of the state governor, those restrictions don't apply. And then it's actually very complicated. You have to look at all 50 states and the four jurisdictions to see what law each state has delegated to the National Guard to enforce. And some states have very, very, very forward-leaning laws that essentially allow the National Guard to be essentially an additional police force. Some states have very restrictive laws, and National Guard can do very little in terms of law enforcement. So it's a state-by-state analysis, all of which to say this is very complicated under the best of circumstances. Now you have two different, frankly, sovereigns that disagree with their status in DC.
And are those statuses and authorities generally worked out in advance of a deployment in the ordinary course, to the extent it's ordinary?
Yes, they are, and this is real time. I think that the last 48 hours there were 6 National Guards. It's when I first wrote this piece for Just Security, and so there's a whole host of questions about how this is all being coordinated. For many of these National Guard members, I imagine this is the first time they step foot in the nation's capital, so they won't be familiar with the surroundings, let alone the DC code.
Or the populations that they're dealing with and what's normal and what's suspicious, all the things that a beat cop learns through experience.
Exactly.
So there may not be an answer yet to this question. Maybe we'll have to do another episode in a week or two. But if other states' guards are coming potentially under Section 502F, the other duty clause, and they start acting outside that authority without an invocation of the Insurrection Act, without any other legal authority, what happens? What legally speaking, what can happen?
So let me put it in two buckets. Let me just say, and I'll, as a former military member, let me just speak to what I view as just, I would hope is the professionalism and the constraints and frankly, the overall respect they'll have towards the mission of each unit while they're in DC. So they all have a chain of command. They will all have lawful orders. They will all be given, here's your left and right limits. I imagine each state JAG is going to be very, very busy in advising on what those left and right legal limits are. And those will flow down from each unit down to the lowest ranking guard member. And so you have a core amount of just following lawful orders, David, that would be followed, right? And so if anyone was to go outside that mission, then you have administrative procedures, you have military justice procedures if you were to violate sort of a lawful order. Now, having said that, if that order itself is arguably doesn't have a legal basis, then you would see litigation. Then I think you'd see civil action against the guard units. That will probably take time because you have to establish Article 3 standing and a whole host of jurisdictional hurdles. But my hope is that the military units being deployed from out of state are being relatively conservative initially in what the lawful orders are how they're being promulgated and what their missions are.
Thank you. Well, that's very useful. It's good background, and I think we've mapped out the legal issues as they're unfolding essentially in real time. I almost feel like I should check the news right now before wrapping us up. But barring that, let me ask each of you. We'll start with Brian. Right now, what do you think the biggest open legal questions are about the executive branch's actions towards law enforcement in DC?
I think the biggest open question, at least on the police side, is what are federal purposes? What are the federal purposes that the president can invoke to use local police forces for his supposed federal purposes? The executive order that the president issued claimed that maintaining law and order in the nation's seat of government was a federal purpose. That would seem, however, to be precisely the scope of power that was originally given to the Metropolitan Police. And if that were a federal purpose, then there would be no local purposes left. So I do anticipate that the courts are going to have to decide where that line is.
Thank you. And Mark, on the National Guard side, are there open legal questions? I feel like we've addressed a couple. What are the biggest ones you think that may be resolved or teed up in this?
Well, beyond the command and control mission and length of time, I'd want to know all these questions and legal authority, particularly for the out-of-state guards to operate in DC, because I do think Mayor Bowser has an argument that they're somehow violating the sovereignty of the District of Columbia outside the federal property. Having said that, DC is just different. It's a federal enclave. It's not, a state. And so if you had the Ohio National Guard entering, say, Chicago against Governor Pritzker's over Governor Pritzker's objection, you'd have a clear constitutional violation. So this issue of in DC without basically the chief executive, Mayor Bowser's sovereignty, is an open question. I think that the Trump administration does have good arguments based upon DC's unique status. And what I'm really looking for is their mission, David. Is there going to be mission creep? We're always worried about that in the military. You go there maybe to do presence operations, maybe to protect federal functions, but maybe you start doing a little bit more. Maybe you start doing more law enforcement, more checkpoints, more sort of day-to-day policing activities. And so when that is triggered, I'm looking to see those posse comitatus act questions addressed in federal court.
Thank you. On the other hand, Brian, are there any clear legal lines aren't murky that we should be watching to see if any of the executive branch's actions cross those lines?
For sure. I mean, the clearest line is this 30-day clock. Some folks were very skeptical that when this MPD police badge was issued for an emergency commissioner, it was issued for a period of about a year, which seems inconsistent with the maximum possibility of there being a 30-day period. That is a clear legal line, and if there's any effort by the administration to try to maintain any form of control over the Metropolitan Police Department after that 30-day period, I think we can expect some quick returns into court.
Yeah, and we'll be checking in on day 31 or so as well. Mark, any clear red lines that the National Guard, not necessarily individual members, but at a more kind of command level, any red lines that could be crossed that we should be looking out for?
So I would say not at this time, other than the questions that I raised, because I just don't know the mission yet, David. I think when they start doing law enforcement, if they were to do law enforcement, then that's an important question to answer.
Thank you. Well, with that, gentlemen, I again appreciate your joining us. This is a rapidly unfolding set of situations. We'll keep an eye on them and hopefully get you back at some point to talk about how things have gone. But for now, thank you again. This episode of the What Just Happened podcast was hosted by me, David Aaron, and produced by Isaac Rubenstein. Special thanks to our guests Brian Netter and Mark Nevitt. You can read all of Just Security's coverage of federal involvement in DC law enforcement and the National Guard on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.